Good evening, and welcome to tonight's installment of the Daniel Webster Debate Series. This series, of course, is named in honor of Daniel Webster, one of our nation's greatest orators, public servants, and constitutional advocates. Founded just last year, the series has quickly become the heartbeat of our chapter and a cornerstone of serious legal conversation here in the nation's capital. By bringing together leading judges, scholars, and practitioners from across the country, we aim to engage the most pressing issues of our time with rigor, clarity, and genuine intellectual exchange. Tonight's resolution asks, is the court moving in the right direction on the Establishment Clause? In recent years, the Supreme Court has significantly reshaped its Establishment Clause jurisprudence, moving away from the familiar lemon test and toward an approach grounded in history and tradition. In cases involving public prayer, religious symbols, and the relationship between church and state, the court has signaled a renewed emphasis on historical practices and potentially a not-so-strict separation of the two. To examine this rich and ever-relevant issue, it is my great honor to host two outstanding scholars and to welcome Judge Matthew Kacsmaryk as tonight's moderator. Without further ado, please join me in welcoming our events chair, Sarah Babu, who will formally introduce our three distinguished panelists. Thank you so much. Thank you.
Thank you, Dennis, and good evening, everyone. Moderating tonight's discussion is the Honorable Matthew Kacsmaryk, United States District Judge for the Northern District of Texas. Judge Kacsmaryk earned his bachelor's degree summa cum laude from Abilene Christian University and his JD with honors from the University of Texas School of Law. Before taking the bench, he practiced at Baker Botts in Dallas, served as an assistant U.S. attorney for the Northern District of Texas, and was deputy general counsel at the First Liberty Institute. He was nominated by President Trump and confirmed by the Senate in 2019 and has been a rising star in the judiciary ever since. Arguing the affirmative is Professor Michael Moreland. Professor Moreland is the University Professor of Law and Religion and Director of the Eleanor H. McCullen Center for Law, Religion, and Public Policy at Villanova University's Charles Widger School of Law. He holds a PhD in Theological Ethics from Boston College and a JD from the University of Michigan. Following law school, he clerked for Judge Paul Kelly on the 10th Circuit and practiced at Williams & Connolly here in Washington. He also served as Associate Director for Domestic Policy at the White House under President George W. Bush. Professor Moreland has published widely on questions of law and religion in journals, including in our very own Georgetown Journal of Law and Public Policy. He serves as Vice Chair of the Federalist Society's Religious Liberties Practice Group. Arguing the negative is Professor Mark Graber. Professor Graber is the Regents Professor at the University of Maryland Francis King Carey School of Law, the most prestigious faculty rank in the university system of Maryland. He holds a PhD in political science from Yale and a JD from Columbia. He is widely recognized as one of the leading scholars of constitutional law and politics in the country, having authored or edited more than a dozen books, including his most recent book, Punish Treason, Reward Loyalty, the Forgotten Goals of Constitutional Reform After the Civil War. In 2023, he received the Lifetime Achievement Award from the Law and Courts section of the American Political Science Association, and in 2025, the Guggenheim Foundation awarded him a Fellowship in Constitutional Studies. Out of breath with all of these accomplishments. We are fortunate to have three such accomplished individuals with us this evening. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speakers. With that, I will turn it over to Judge Kacsmaryk.
So this will be easy. I can let the experts take up most of the oxygen, but let me give a brief introduction to our topic. So the text of the Establishment Clause is simple enough, right? Congress shall make no law respecting an establishment of religion. But because the clause is necessarily analyzed alongside the religion and free speech clauses, Supreme Court jurisprudence oscillates between separationist and accommodationist views, depending on the court's composition and the nature of the governmental interaction, interference, or support. And as an example of some of that oscillation and variation, we'll run through a few landmark Establishment Clause cases that led to this point. So most famously and firstly, Emerson's Wall of Separation, where the court cited Thomas Jefferson's 1802 letter to the Danbury Baptists to erect a high and impregnable separationist barrier between church and state. The Shem test followed in 1963, which was a precursor to Lemon, and it focused its inquiry on the secular purpose and primary effects of legislation. And then you'll hear this over and over tonight, the most famous and most relevant to this debate, the 1971 limit test, whereby a challenged law must have a secular legislative purpose, must have a primary effect that neither advances nor inhibits religion, and must not foster excessive governmental entanglement with religion. And after about a decade of haphazard application, Justice O'Connor squeezed the lemon into an endorsement test, which focused on what a reasonable observer would perceive in a given case, most famously in Lynch versus Donnelly, and we all know that the de facto reasonable observer is, of course, Sandra Day O'Connor. In the 1990s, Justice Kennedy proposed a different reading, or squeezing of lemon, focused more on coercion as an element. During that same time, and by the way, this was my adolescence and young adulthood, the 1990s, Justice Kennedy was proposing a different reading that was intensely focused on coercion and showed up in cases like Santa Fe. So these are cases involving school prayers, school events, and any perceived psychological harm one would endure if you're made to view anything that's distressing psychologically. During that whole time, self-identified originalists and textualists openly mocked the lemon test as a make-believe monster. Most famously, Justice Scalia's concurrence in the 1993 case, Lamb's Chapel, where he said, like some ghoul in a late-night horror movie that repeatedly sits up in its grave and shuffles abroad after being repeatedly killed and buried, Lemon stalks our Establishment Clause jurisprudence. So I actually had Justice Scalia as a professor. I did the boondoggle summer semester that a lot of the justices do, so he was actually always laughing in class when we would go through that case. He was pretty proud of that one. Finally, in 2022, the originalist and textualist expressly rejected the lemon test in a case litigated by my old law firm, First Liberty Institute, Kennedy versus Bremerton. Writing for a majority, Justice Gorsuch declared that the ambitious but abstract and ahistorical lemon test was long ago abandoned, and he cited Town of Greece and the American Legion as recent examples, which leads to the question, what comes next? What of this trajectory? And that's the subject of tonight's Daniel Webster debate. Is the court on the right trajectory? Is it doing the right thing in the way it is testing and applying the Establishment Clause? So for the affirmative, I will start and allow Mr. Moreland 7 minutes, and then we'll follow with Professor Graber and his 7 minutes, and I'm going to put you on the clock now.
Well, thank you very much, Judge Kacsmaryk, and thanks to Dennis and the other officers of the Federal Society here at Georgetown for the invitation to participate in this debate, and it's an honor to be alongside Professor Graber. So is the court moving in the right direction on the Establishment Clause? Well, I'm going to underscore a little bit what Judge Kacsmaryk was just talking about, the state of Establishment Clause jurisprudence in, let's say, roughly the 1990s, probably a little bit before some of you were born. As Judge Kacsmaryk said, Everson, beginning in 1947, had selectively invoked really historical evidence about the importance of separationism, the wall of separation metaphor, taking a letter that Thomas Jefferson had written actually after ratification of the First Amendment to become kind of the central governing metaphor. And so this separationist move, this separationist focus really informed the court's jurisprudence in this area for well over half a century. And as the judge said, Lemon versus Kurtzman in 1971 was in some ways maybe kind of the central and high watermark for this. Law must have secular purpose. Primary effect must be neither to advance religion or inhibit religion, and the law must not result in excessive government entanglement with religion. But like so much else in the Warren and Burger Court eras, that was all made up. It was all made out whole cloth by Chief Justice Burger and Lemon versus Kurtzman, and it became this effort to create a kind of grand unified theory of the Establishment Clause through the Lemon test, but it was never even successful on its own terms. But if you just think about, as I say, the state of the jurisprudence in the 1990s, it was a massively unpredictable and unstable line of cases. So the court in Everson itself, 1947, said, yes, it was okay for a school district to fund, or for a township to fund bus transportation. In 1968, the court said it was okay for the state to provide textbooks in secular subjects. The court said it was okay to have aid provisions, grant provisions for colleges and universities. And of course, there was always, throughout this period, there was a lot of government funding for religious hospitals and religious social service agencies. But the court said no to things like salary supplements for teachers in religious schools. That was actually Lemon versus Kurtzman itself. Facilities grants, tuition grants in Nyquist 1973. The court said no to instructional materials, so maps and photographs, things like that, because they could be diverted, they said, potentially to religious uses. Couldn't have that. Auxiliary services such as special education were unconstitutional. Test administration costs were unconstitutional. Field trip funding was unconstitutional, and remedial instruction was unconstitutional, according to Aguilar versus Felton in 1985. And I hasten to say, I don't think even the people who were sometimes defenders of Lemon thought that that there was any sense to this whole line of cases, the way in which the court was slicing and dicing whether textbooks could be funded by the state, but maps and photographs couldn't. And that's just on the funding front. You also had a line of cases involving, of course, school prayer, famously Engel versus Vitale in 1962, Lee versus Weissman in 1992, in which the court said that sponsored prayer in public school settings was unconstitutional, but in Marsh versus Chambers and in Town of Greece versus Galloway, even more recently, just a decade ago, the court said that it was permissible to have legislative prayer. And then the third big bucket of Establishment Clause cases, public displays of religious symbols. The court famously in 1984, purporting to apply, again, this Lemon framework, says in Lynch versus Donnelly that a nativity scene with Santa and reindeer is constitutional. This gives rise to the so-called three plastic animals rules in the public display context, but says in County of Allegheny versus ACLU in 1989 that a creche at a courthouse is unconstitutional, but a menorah with a Christmas tree is constitutionally permissible. And on the same day, in 2005, the court says that a Kentucky courthouse display of the Ten Commandments is unconstitutional, but a Texas Capitol State grounds display of the Ten Commandments is constitutionally permissible. So again, it was by any measure a confused, unstable, unpredictable area of constitutional jurisprudence. And that was because, in many ways, because of Lemon itself. As Justice Alito points out in his majority opinion in the American Legion case in 2019, it was hard to tell what the original purpose of a law was. Purposes can multiply over time, they can change over time, and that removal in the display context, for example, might not, after a long time, be neutral toward religion after all. Well, fortunately, and obviously I'm on the affirmative side on this issue, fortunately, the court, beginning in the 1990s and then very rapidly culminating over the ensuing 20 years or so, chips away at this confused area of constitutional law. Beginning with cases like Rosenberger in 1995, which was actually a free speech case, in which the court said that the University of Virginia's refusal to allow subsidies for the publication of a Christian student newspaper, that was unconstitutional. Actually, the court reverses its own judgment in Aguilar versus Fulton and Agostini versus Fulton for special ed teachers in schools. And then, of course, in Zellman versus Simmons-Harris in 2002, you really start to see the house of cards come down when the court upholds the constitutional permissibility of a voucher program in which parents are exercising independent choice to direct vouchers to private, including religious schools. And as I say then, in the public display of religious symbols context, with the cross case from actually nearby here in Prince George's County, in the prayer context with cases like Town of Greece versus Galloway, and in the funding context with Zellman, and then the ensuing cases in that line, I think the court has made dramatic moves toward cleaning up and rationalizing this whole area of First Amendment jurisprudence to be consistent with the text, history, tradition of what the First Amendment actually says, and the underlying purposes that the Establishment Clause narrowly was meant to accomplish. No national establishment of a church, and respecting the state establishment of churches that existed at the time of the founding. So we'll have plenty of time, I think, to talk a little bit about what then comes next. I think that, as Justice Gorsuch said in his concurrence in the Boston flag case, there is scholarship in this area by primarily Michael McConnell, but others who talk about, well, what were the historical markers of establishment at the time of the framing of the First Amendment? Things like control over church doctrine, compulsory church attendance, compulsory financial support and taxation to support clergy, prohibitions on worship in dissenting churches, restriction of political participation to members of established churches, and use of church institutions for public functions. Those are the historical markers of establishment, and insofar as things today are analogous to those, then the Establishment Clause still applies, but the whole experiment that the Berger and Warren courts undertook under the guise of separationism was a massive mistake, and fortunately the court is now amid correcting it.
And I'll note, as a preview, I believe your own Professor Barclay is working on a paper relevant to those markers of establishment through the lens of a history, text, and tradition approach. So, yay, Georgetown. So now we'll turn to the negative. Professor Graber, you've got 7 minutes on the clock.
Thank you very, very much. It's an honor to be here. It's an honor to be with both of you. I can't resist in my desperate plea for sympathy. This is my Dartmouth College tie, which I share an undergraduate institution with Daniel Webster. So I get something. Now, I may be taking a little bit of an orthogonal position in that it's less a debate from my side between liberal, conservative, or however you want to describe, that I think Professor Moreland thinks the outcome of these cases is very important. I actually don't. Professor Moreland is a very distinguished scholar of law and religion. I'm a 19th century legal historian who, when I wander outside of that, does comparative constitutional law. And if you ask what am I doing here, the first thing is, well, the Federal Society usually has better food than liberals I'm with. And it's also just really a pleasure where I can say something edgy and not have everybody nod. See, the whole point of saying things edgy is to stir up a debate, and I'll try to do so now. What do I mean by, in some ways, this is a debate between someone who cares and someone who doesn't care? I think that if every case on my list, the Bladensburg Cross, coach praying at the 50-yard line, whether a few courts post the 10 Commandments, whether a rural town in upstate New York has a little prayer before a town meeting, whether when you're ducking spitballs while they're saying the Pledge of Allegiance in 3rd grade, they say under God. I think no matter how they come out, there's religious liberty in the United States, because where in some ways I'll agree, my notion of religious liberty comes from my grandparents and their memories of great-grandparents being Jews in Soviet Russia, where you got killed for being a Jew, where your children were taken away. Now, do I think, for reasons I may get into, you can post the 10 Commandments, which, by the way, my religious faith is called the 10 Statements, so you're making your religious decision by your very title? I think no. Do I think that means there's no religious liberty? No. And so I just don't get excited by the cases. But I think when you think they're important, you say something. So one of the things that concerns me, it actually concerns me with both majority, concurrence, and dissent, you think religious liberty is at stake when, in fact, whether we can keep the Bladensburg Cross. And I want to say, none of these 9 justices know from religious persecution. Religious persecution is having your kid taken away because of your religion. It's not seeing the Bladensburg Cross, which may be unconstitutional, and maybe Felix Frankfurter said, not everything constitutional is wise. One thing I want to get across is not everything unconstitutional is evil. So one thing we can agree, here are the evil manifestations of establishment. There may be other things which we decide violate the Establishment Clause, even though in fact we could live with them and we still have religious freedom. That one of the features of religious freedom, like I say, it's an internally contested concept. I'm going to promise you that if the Roberts Court delivers on what religious conservatives wanted to do, there will be new demands made to push it further. And by the way, if for some reason they see the light, the left will make new demands. The question always is with religious freedom, not who won the latest fight, but where we are, and I'm here to report we're in a good place, and I wind up disagreeing with Neil Gorsuch, who constantly says this is the experience of persecution. It's not. The second thing that I think can go wrong is you wind up making silly statements when you overlook the importance, or you overestimate the importance of cases. So in the Bladensburg Cross case, and in some of the Kresch cases, we hear things like, well, everybody knows a cross isn't a Christian symbol. I haven't met a Jew who says, oh yeah, that's just neutral. The thing that we were supposed to kiss or be killed, that's a neutral symbol. Now it may be that it's not worth the bother taking it down, but you tend to inflate when you're overestimating importance. And I will say a couple things on history and tradition, which is supposed to replace Lemon, because there are two problems, which I'll probably go into a little more with history and tradition. The first is the Roberts Court history and tradition is whitewashed in a weird way. If you look at the Roberts Court, they say, well, we don't want this practice because it's a product of the anti-Catholicism around the time of the Reconstruction Amendments and also around the time of the framers. Well, guess what, folks? That's called history and tradition. If history and tradition is going to be a neutral test, we don't get to pick the traditions we want. We have to tar and feather and roll people out of town if that's the tradition. The second reason is it turns out that historians, some of whom, unlike McCullen, have a PhD in history and have to answer to peer-reviewed publications, disagree. I'm not going to tell you that the evidence is entirely on the side of people on my fence. What I am going to tell you is that in most cases, both Establishment Clause and others, the judges get briefs by responsible historians on both sides of the fence. They have no capacity, and I emphasize no capacity, to decide among them. So at least Lemon, which I don't like all that much, said, well, here are 4 things to consider that have some relationship to the framing, and you can figure how they made a decision. But we don't know why Justice Thomas picks historian A rather than historian B. And so history and tradition has all the flaws of the Lemon test, and I think lacks its limited virtue. Thank you. And thank you for the 15 seconds.
Yeah, I give it back, because he took 15
Yeah.
seconds. Yeah, I need to be fair and
Over
impartial.
7 minutes.
We're pushing it.
I need to be fair and impartial at all times. Okay. So what we decided to do from this point forward is take on 3 topics. So I'll present the topic, we'll follow the same format, affirmative, then negative, but then at the close of each topic, open it up to any questions from the audience. I'll try to be a good timekeeper, keep us on schedule. But let's start with topic 1. So we've come up to Kennedy in our recitation of the different cases, and what replaced or should replace Lemon after Kennedy. And if we have time, let's focus on some hot-button issues like school prayer, Engel versus Vitale, and its progeny.
So what should replace?
Yeah, what should replace it, and what do you think is coming over the horizon?
Well, I think that something like the, and obviously this is a field of ongoing scholarly debate, but something like the markers of establishment that people like Michael McConnell have pointed to. Because remember, the Establishment Clause, as an original matter, had a very narrow scope. It prohibited the national government from establishing a national church. It's actually one of the departures in the Bill of Rights from the English legal tradition, because other things like freedom of speech to some extent and the right to bear arms and so forth had analogs in either the English Bill of Rights or other common law traditions. But it was a departure to say we're not going to have an established national church and to leave in place and to respect the state establishments. And again, there were certain things that went along with having an established national church and the state established churches, and most of them had to do a lot with coercion. either coercion to fund or to attend worship services or to be a member of an established church. And so, again, that's the original understanding of the Establishment Clause, I think. And it seems to me that this return to tradition is not, I resist a little bit the idea that it's completely kind of up for grabs and that, historians disagree on at least a couple levels. On the one hand, I think that just as they can in other evidentiary contexts, judges can sift through and read the competing historical evidence. And they have to do this in complicated toxic torts cases and other fields that are that you don't learn about at Georgetown Law School, and they can make the best light of the evidence that they can. I think the same with history and tradition. And again, by refocusing on history tradition, I think it means then that we can focus on those things that are truly important to the concerns that motivated the framers of the First Amendment, and set aside the ones such as when funding is provided on a neutral basis to religious and non-religious entities, that's something that, and also I think in the context of public displays of religious symbols, those are, I think, are things that are clearly outside the ambit of what the Establishment Clause is worried about. School prayer, I actually think, is a much harder question. Because there, especially Engel itself, as you may know, involved a state-composed prayer that was recited at the beginning of the school day. I think there, the concerns about coercion and state orthodoxy are much more present than they are in some of these other contexts involving funding and displays of symbols.
Okay, so with that, I'll give you 3 minutes to argue the negative, and then we'll open it up to questions from the floor.
What's going to follow versus the empirical question? I suspect something like history and tradition according to Professor Moreland, and I don't say this was at all.
I hope.
No, yeah, you hope, yeah. And in one sense, I don't mind, or two senses. One, I don't mind because, as I've said, while I think I disagree as a matter of establishment, I don't think anything he's proposing violates, quote, big religious liberty, even violates the Establishment Clause. A second is I'm inclined to think that every winning political coalition gets to choose its history. Okay, so there's reasonable history out there. There's reasonable history on my side. Just we understand that what's going on is not the neutral sifting of history that takes place ideally in the Journal of American History, but remarkably, the conservatives on this court tend to believe the conservative historians, and the liberals on this court tend to believe the liberal historians. And by the way, if you look at the history of history, the history of Reconstruction, who was central to Reconstruction, for example, depends on the politics of the time. That history isn't quite as neutral as we sometimes pretend it to be. So that's, as far as predictions, what will happen. I'm inclined to think the framing is more messy, that it doesn't really rule out a lot, in part because, remember, the framing doesn't have a welfare state where the federal government is involved, government is involved with pretty much everything. They were writing for freedom of religion on the assumption that nothing is being funded. What happens when everything is being funded? We don't really know. And one of the things worth looking at, Madison vetoed 2 bills on First Amendment establishment grounds. One involved funding, the other didn't. And claim has been made that Madison's a bit of an outlier. It's interesting to read the limited congressional debate afterwards. And the good news is it's available on the Founders Online, and it really is easy to read. It'll do bedtime reading. And there are some people in 1811 who say, go Madison, you're absolutely right on the Establishment Clause. There are some people who take the position, no, there's going to be this guy, Professor Moreland, 200 years from now. He is absolutely right on the Establishment Clause. Your vetoes we're fundamentally wrong. And there's my favorite. Say, why are we bothering talking about whether this society in Alexandria gets to be incorporated by Congress and whether we're going to spend a little money for a church in Mississippi? We've got much more important things to do, and that is my view of the history and tradition.
And like every good streaming show, I have to interrupt for a commercial. I actually grew up with real commercials. I just got teased into following streaming services, thought it was free, and then got hit with commercials later. So a really good illustration of Professor Graeber's point is encapsulated in Philip Hamburger's book, Separation of Church and State. So you think it's going to be a jurisprudential treatise, but it's actually more echoing in Professor Graeber's field. It's a historical take on what that phrase meant, how it was used politically and rhetorically through multiple elections, and in an alternating sine wave in one man, Thomas Jefferson, who took both sides of that debate, depending on the election and depending on the political environment. So if you want if you lean towards the history side of this debate, and that's your inquiry, I would definitely look to Philip Hamburger and his book on separation of church and state as an example. So, on topic one, what replaced Lemon? What should replace Lemon? How is that going to affect future hot button cases? Anything from the audience? You have two experts at the helm.
Yeah, I was curious about the application of the historical hallmarks test. I mean, the court hasn't had much of an opportunity to talk about it, if at all. It came up in Gorsuch's concurrence and Shurtleff. And so, in terms of how the court would apply it if they would adopt it, do you think it's a disjunctive test? Is meeting one of the hallmarks enough for the court to find coercion? Is it 2? Is it 3? Is it all 6? Is it and what level of generality needs to be? Because I think the welfare state point is a really great one. Financial support for religion might mean a very different thing at the founding than it does today.
Should I start?
We'll do affirmative, negative. We'll stay with the pattern.
Great questions. I think they're sufficiently different that they're sort of disjunctive, so that you could imagine instances of the state giving over power to churches, for example. And so that's why I think a case like Grendel's Den, which is the case involving whether or not was it Cambridge could basically let churches have a veto power over the location of bars in Cambridge. Actually, Grendel's Den is still there in Cambridge, Massachusetts, if you want to go visit it. So cases like that, I think, those are analogous to some of these historical markers, and that's very different than, say, the funding question, different again than coerced worship and things like that. I do think that many of them, though, do, I think, sound in coercion. So I think that has rather than the earlier iterations of this area of law, like in endorsement and things like that, I think coercion has become much more central to the analysis. But you're right about the level of generality question. So, for example, with regard to funding, I think that at the time of the First Amendment, when we talked about funding, I think we were primarily thinking they were primarily thinking about coerced taxation in support of clergy and churches. Now, to what extent then does that analogize over to things like, for instance, funds from the public treasury going to religious uses on a neutral basis, which I think is fine, and I think in part that's because there are ways in which the state is much more involved with providing funding for things like education and social services now than certainly it was in 1791, when there really weren't public schools as we certainly know them today. But you're right that some of those levels of generality questions, as they have come up in the Second Amendment context and other contexts in which this history and tradition framework has come to the fore, those are things that have to be worked out. But I guess to come back to the question we're debating on the slide up there is, this is a lot better. This is a lot better, and certainly more sound as a legal, constitutional, interpretive matter than what we had before.
Any response?
Just briefly on hallmarks, one of the differences between historians who tend to work out of history departments, who tend to see their primary audience as a history department, and historians who work out of law school, and I'm probably in the former, is a major theme of a good deal of my writing on history is they thought about things differently than we do. That we need to appreciate the differences and be wary of analogies. The major theme of historians who operate out of law school is they're concerned with contemporary issues. And so they start with, what would George Washington have thought about the designated hitter rule had he been alive today? Yeah, but that's what it feels like to historians like me, whereas I'm trying to figure out, for example, in the Punish Treason book, is what did Republicans think was the central problem after the 13th Amendment, given their view of history and the conceptual apparatus available to them, which is quite a different, I argue, conceptual apparatus than we have. So, from an historian's perspective, trying to find analogies to what was going on in the early 19th century is fraught. It's a bit like, I like to call abortion, the battle of bad analogies, where someone tries to say, okay, what's the experience men have that is most equivalent to pregnancy? Answer, none.
Okay, any other questions on topic one?
So it seems like coercion is a word that comes up a lot in this new line of jurisprudence. I mean, anytime you have Justice Kennedy and Justice Gorsuch using the same word, you figure it's going to stick around. Do you see the court going in the direction where coercion means, like an 18th century style, we will throw you in jail if you don't go to church and nothing short of that is coercion? Or is the sort of Lee versus Weissman, well, you'll be embarrassed in front of the rest of your graduating class? Do you see the court taking that to be coercion?
So we'll start with Professor Moreland, followed by Professor Graber.
I mean, I don't think it's only the former, to be clear about that. And that's why I say, and I think in his recent book with Nathan Chapman, I think Professor McCullen takes the same point about school prayer I was kind of echoing earlier, that school prayer, either in the school composed context, like in Engel, or maybe in context like the graduation of Lee versus Weissman, I think maybe moments of silence might be different. If we want to get down to that level of detail. But I do think that I do think coercion is now very much the central consideration, and I think it means coercion not merely in the kind of way that you said initially, but of course I think it would be a mistake to maybe over psychologize it too. So that the fact that there's a war memorial cross in Prince George's County isn't coercing anyone, and that's why I think the court got that case right. And in fact, that case I think has kind of ushered in a whole new era of line of cases or about public displays of religious symbols, because there's I just think that whatever coercion is occurring there is coercion that's outside the worries of the First Amendment.
So I'll coerce a response from Professor Graber. You're hereby ordered to respond.
You force me. I am inclined to agree here, since we're talking empirics and not theory, that in the future, coercion is going to be where the battles will take place and not endorsement. I think that's right. I think you're probably right that I would not invest heavily in Lee versus Weissman stock for the foreseeable future. Indeed, I worry that right now, to be perfectly honest, if I had the power, I might say, give Michael McConnell the fifth vote on the Supreme Court. I think, from my perspective, I might be better off. That I worry that even in some of the areas that you say you're worried, that this court will be less worried, that it may turn out that while I represent, say, Kagan on the court, you're closer to representing, and I'm hearing you, John Roberts, or a justice trying to be in the middle of this court than where the justices may wind up in the long run.
Okay.
That in some sense, each of us represents the center of our political factions and not the wings of them.
It's for Professor Graber specifically, if that's okay. So it seems like you don't think history tradition has much value, I guess, in jurisprudence. So how would you, what cases do you think the court should take in the Establishment Clause? Is it only when there's true injustice, when there's true coercion, when there's, I guess, what do you think about school prayer context? If you were a justice, what kind of cases would you take and how would you rule on that?
I'd be tempted, I was almost tempted to say, I think a lot of these cases are in the muddy area of religious freedom. I'd be wildly tempted to take two cases and come up with inconsistent results just to highlight that this is a muddy area. I'm not sure consistency is actually the best virtue. I'm inclined to think I would, on the court, much as I disagree with it, I'm a compromise kind of guy, and I would like the Rehnquist play in the joints. And that is emphasize in the muddy areas, we're going to go with the legislature. If the legislature says don't fund the scholarships, we're going to do that. The legislature says fund the scholarships, we're going to do that. So that would be here a strong emphasis on restraint, unless I really saw this as something that starts to move into the real, no, this is closer to religious persecution.
Got it.
And from the front row.
Just building on that, Professor Graber, you mentioned that you're uninterested in a lot of Establishment Clause jurisprudence. As a fellow Jew, I can see where you're coming from. Where would it start to change for you? At what point would you start becoming interested in Establishment Clause jurisprudence? What things would have to happen for it to be interesting?
Yeah, I don't know. One of the things that I'll say is it's interesting. I would have to point out to Robert Bork's book on what conservatives should do if they ever got control of the national government, and they did none of it. And so what would I do in changing circumstances? I do not anticipate any circumstances in the near future where I'm deeply worried about religious freedom. At times, Pete Hegseth says things that I worry about, whether a Jewish or a Muslim person in the army will be fair advancement. I could see there, I think, there is a bit of Christian nationalism in the Trump administration that, in fact, carried on to something more than lots of prayer services in Hegseth's office. If he wants to do that, sure. I would worry about and want to monitor. But my real message is religious minorities have it good here. It's not to say we shouldn't argue over religious freedom, because I think religious freedom has dimensions that do not involve persecution. I think there are violations of free speech that are not forms of repression. But barring, what I'll say here is the hallmarks of 18th century are where I start to get worried. Our difference is I would not limit the Establishment Clause to what Jews experienced in 19th century France. But I would get worried if we started to look more like 19th century France.
Anything from your
No,
perspective?
we can go on to the next topic.
Okay, so I'll turn to topic 2 so we can get through all three. Topic 2, what upcoming cases could give the Roberts Court an opportunity to further elucidate its view of the Establishment Clause post-Kennedy? And we had as some potential examples 2 categories: 10 Commandment displays, 2 cases I think Professor Moreland has flagged from my Fifth Circuit And then also pending cases on religious charter schools, or one that was decided, not decided. So in those two categories, what do the experts see as lodestar cases to watch out for?
Well, at a general level, I'll say that I think the court is going to take and decide a lot fewer Establishment Clause cases than it was, say, in the 1970s, and I think that is entirely a good thing. Because as I was, marching through that series of cases from the Lemon era, where the results were unpredictable and erratic, and they were taking cases involving crash displays with Santa displays and all that. And I think that the fact that now we live in a much, as I say, much more sound Establishment Clause era, but also it means an era that will be less judge-centric, and it will allow, as Justice Scalia said in I think it was in dissent in Lee versus Weissman, it will kind of allow the traditions of the American people in many local places to be left untouched by the federal judiciary, which at least in this respect is a good thing. With the federal judge sitting next to me here. Having said that, I do think that
Well, I don't want to do the interior decorating.
Right.
That Scalia was always complaining about.
Right, I do think that there's still, which doesn't mean they'll be out of the business altogether, though, and I do think the two you flag are important ones. One is, I think, even post-American Legion, I think there will still be some display cases potentially, in part because there's a kind of leftover ambiguity, or at least open question in the American Legion cases, which is, well, what happens if you have new displays that have a strong religious component to them? Because part of the analysis in the American Legion case was, well, the purpose for this War Memorial Cross has been there for 100 years. It can change over time, and to tear it down now would, in its own way, be kind of hostile to religion. But what do you do with new displays of religious symbols, such as Ten Commandments displays in classrooms and the like? So I think that's one area. And then this issue about the Oklahoma charter school case, and whether or not you can have religiously funded charter schools, which technically speaking is a free exercise issue, about whether that is the latest iteration of the Espinoza Trinity Lutheran Carson line of cases, that if the state, and a lot of this depends on the particulars of each state's charter school statute, but if the state treats charter schools as effectively independent contractors, but then says, but you can't have a religiously operated charter school, I think that flies in the face of that line of cases, which is a free exercise non-discrimination rule. But of course, in the back of it, there's also a view that the kind of hyperactive Establishment Clause worries, which had been part of the motivation of governments in cases like Rosenberger, in the school access cases like Lamb's Chapel, in contexts like the Boston Flag case, and in Kennedy versus Bremerton, that kind of over-reading of what the Establishment Clause prohibits, I think will be part of, it has to be part of that issue, but technically speaking, it's squarely more a free exercise question.
Okay, so anything you're looking at, I know you're a historian, focus on that, but anything in the 10 Commandments statement or suggestion line of cases?
I think we're likely to see more things I think are Christian, described as secular. And though, again, those don't make big splash. I think Professor Moreland, something I want to agree with strongly, I think it's a very important insight I actually want to highlight. I think where the rubber is going to hit the road, and I think the charter school case is maybe one of them, is that the judges are on board with when it appears to be the religion driving the train. They get the funds, which people say are neutral. It is when the school officials, when the government starts to get a little more involved. And at least for one judge, the charter school, I think, marked that point, that judge, we don't know which one, saw this as closer to Engel with the schools writing the prayer than not. And I think these are going to be the cases that will splinter the Roberts Court if the Roberts Court remains as is. I think we're making that assumption now, that it won't be the case that Roberts becomes the only liberal on the court, and it won't be the case in the near future that I wind up saying, wow, this court is way too liberal.
And as a historian, can any of those shades of difference between blocks on the court be explained by history? Can you understand Blaine amendments? Can you understand a certain sensitivity to that issue without understanding Protestant Catholic schooling as we go state by state historically? I mean, they're going to have to look at that history now.
Well, here's the interesting feature. When we were in school, and particularly the two of us, you're a little younger than I am, young guy, I remember even reading texts in grad school, Protestant, Catholic, Jew. Those were the lines of division. Now, go to competing abortion rallies. And what do you see in the pro-life rally? Got Catholics, conservative Christians, and Orthodox Jews uniting. And in the pro-choice rally are Catholics for choice, Unitarians, and my rabbi, Reform theology. This is where I'm coming from. And so one of the things the court hasn't fully worked out, every now and then there are still statements of the older tradition, but most of our disputes now are not between Protestants and Catholics, they're not between the religious and irreligious. I'm sorry, I go to my Reformed temple. They're between people with different notions of religion. We fight the Orthodox as hard as everyone used to fight us.
Yeah, and so if we're going to do a history-centric analysis, I just see a more and more outsized role. So I'll break from my moderator mode here. I think you get a preview of the role of history, archiving, databases, even AI maybe in the future, in the Second Amendment categories. So now I've got to scour the database for archives to determine whether a spring-loaded trigger implicates Rahimi or Bruin in some sort of way that's analogous to a device that was generally available at the close of the 18th century. So I've got to I got to scour the archives to determine whether a sawed-off shotgun is sufficiently analogous to a Swiss Blunderberg or whatever they're called. That sort of work, I think, you're going to see a more and more outsized role for historians, people who can marshal that evidence. You guys read the Supreme Court cases, but we're the fact finders in the most inferior court, the district court. And that's where I think you can see it. And I do think that's going to be an on-ramp for a different mode of advocacy that we saw growing up in law school or even teaching law. So just another advertisement.
Okay. I said to add one thing, and that is we're very, very grateful in the history profession for history and tradition, because a lot of us are making a lot of money as expert witnesses.
There you go, that's my point.
Which we never made before. So.
Okay, so our final topic, and then I'll try to open up this one a little better to floor questions. So the case I started with was Everson. And do you actually think, with this trajectory the court is on, the court is poised to overturn or at least reconsider Everson? And if you want to also address Justice Thomas's repeated refrain that incorporation of the Establishment Clause is ahistorical, you may do so.
Well, as to Everson, as those of you who've taken a First Amendment course or taken law and religion know, I mean, Everson is peculiar insofar as the first few pages of the opinion are this highly selective historical rendering that about separationism, and then the last part of the opinion upholds the New Jersey bus subsidy transportation program for private schools because it says it's a provision that's provided on a neutral basis. So As to that, I think the earlier part, the first part of Everson, the bad history part, I think that's now been thrown out to the extent that it means it's been overruled, or at least it's been superseded. On the aid part, I think that Everson, today, would come out the same way, even more strongly, because of the way in which the court has gone with some of the aid cases. So that's as to Everson. As to incorporation, I do think, and here again, I think Professor McCullen and others have made these kinds of arguments that, yes, Justice Thomas is right that the protection of state establishments aspect of the Establishment Clause is a federalism provision, that it seems highly peculiar would then somehow be a provision that could then be incorporated against the states and local governments. But there's also the non-establishment of a national church aspect of the Establishment Clause, which sounds in many respects in something like a right of not being coerced with regard to religion. And so as to that, I think that much as I admire and respect Justice Thomas, I think that his views on that will remain unique.
Okay. Response from Professor Gray.
I think, once again, predicting, I agree with you that the wall of separation in Everson has been largely breached, and to the extent there is rubble remaining, I expect that to be cleaned up a little bit, but then the rubble is going to have to figure out what do we mean by non-preferentialism. That I think there's a collision coming between the Supreme Court stating we're not going to look into the sincerity of anybody's religion, but we're starting to move towards exceptions for the true believer. Those are going to collide. Incorporation is interesting. It's interesting for a number of reasons. One, remember that even if we think the First Amendment Establishment Clause is a federalism procedure, what about thinking of 1866? 1866, 1868 are the relevant years, not 1791. And there, I think we more see, as we see now, sort of a merger in establishment free exercise. We've had trouble keeping them apart. They had trouble keeping them apart. Now, we get to the next feature, and this is, once again, historians is not quite as neutral as you think. Nowadays, I've wanted to write a piece saying, if you're a progressive, what's so wonderful about incorporation? Let's just look at the Roberts Court and how many cases that incorporation helps us and how many cases it helps them. So one of the reasons why conservatives may be loath to now challenge incorporation is when you control the court. You don't want to get rid of the incorporation doctrine. And I'll leave you with one last thought, and this is a little bit of my own writing for the Punished Treason book. Punished Treason book argues that outside of John Bingham, nobody much cared about Section 1. That if we look at the classic writings on incorporation, it's John Bingham speaks, and by the way, Howard reads a speech that was probably written by John Bingham. You don't see incorporation anywhere else, mostly, because nobody's concerned with Section 1. In 1871, there are a few references to incorporation. They're all by Democrats who now want incorporation for martial law. So could it be that for reasons I totally did not think of when I began this project, and I may not have lived to write the 1871 part of it, liberals will start saying, Curtis was wrong. Graeber may be right on the history of incorporation, but what this does say, again, is the danger of history is not a constant. Just ask yourself, in any era, who are the most important framers? And every 30 years they change.
A little bit like presidential biographies, which go in fad waves. Okay, so I promised to open up the floor. We'll close with questions from the audience. I'll just open it up to any topic or one that we may not have covered.
The sort of evolution of how the court has curtailed Lemon is both a blessing and a curse, because I think what it did in Kennedy by saying it abandoned Lemon is a bit odd. It didn't overrule it, but it it's basically cast aside. Do you think the court should take a case and just explicitly overrule Lemon to sort of stem any mischief in the lower courts? I think there are still some courts who are, at least if not relying on Lemon explicitly, relying on cases that do rely on Lemon, and that's leading them to produce the same sort of contradictory results that are sort of the hallmark of the Lemon era.
I mean, I don't know how much of a difference it would make. You're right, it might make a difference in terms of lower court adjudication, because there are still some, the rubble of separationism and the law of separation. Things like entanglement, which was one of the part of the Lemon test. I mean, that still is part of things like the ministerial exception, I think, for instance. So there are aspects of it that are still kind of floating in the air. But Justice Gorsuch's point was that he avoids the language of overturn, says we abandoned it, in part because the court hadn't been using Lemon in many of these cases. Zellman, for instance, and all these cases in which the court really wasn't invoking Lemon either at all or in any way like it was initially formulated in 1971. So, but I think that now, the message is pretty clear that a kind of wooden application of the Lemon test, like the Ninth Circuit, for instance, had undertaken in Kennedy versus Bremerton, that any kind of wooden application of Lemon is off the table, and that it's history and tradition, analogizing to markers of establishment, and I'm not sure that that much would be served by kind of putting an exclamation point on that anymore.
Yeah, just real quick, if you remember my chronology as we go through Everson, Shemp, Lemon, Lynch, all the way through Lance Shapley, and then finally Kennedy. That's the problem, is some of these ancillary concepts like coercion and endorsement, which echo some concerns that will continue to be litigated, they all cite Lemon. And so you guys grew up in a world of Echo, Google, word search, algorithms. You just ask the computer and spits something back. You're growing up now with AI. I don't know what a district court's to do when it just keeps getting that concept using those words. And so at some point we're going to have to disaggregate that.
Can I drop one quick footnote too? There is a project, this religious discrimination tracking project, is a website that points out that a lot of government funding programs that were created or revamped in the 1970s and 80s were all kind of Lemonized, that they have exclusions for religious participants and things like pre-K daycare centers and things like that. And that's an issue where challenges to those exclusions of religious participation, or just the legislatures going through and kind of cleaning that up, because all those things I think now are more or less unconstitutional, but they were enacted in the kind of with the wake of Lemon in the background, and I think that's a way in which this issue about Lemon will continue to play out.
Professor Gray.
One of the things as a progressive I love about the Roberts Court is everyone, all nine were egomaniacs, and they do not defer to others. As in past courts, you always had in past courts a Justice Tom Clark who voted and said, yeah, write the opinion, fine by me. The result was a justice with a strong view could write an opinion, have 5 votes, and the lower courts would know what it is. Now, you look, you've got 6 different opinions to take the tariff case, right, where I'll have to highlight. Gorsuch really says, I have to write to respond to Barrett. Barrett says, I have to write to respond to Gorsuch, to which, editing a casebook, I said, why did the two of you just not write at all? So the problem may be that we have 6 justices who want to get rid of Lemon, 6 justices who disagree how. The result is different signals, and the result is if you're now one of the remaining liberals on the Ninth Circuit, you can probably piece together a set, a little bit from Gorsuch, a little bit from Barrett, a little bit from Roberts, and say, you see, I'm consistent with Supreme Court precedents, and you just hold in so your nose doesn't grow.
So the camera's off at this point, I hope. So I often joke with my law clerks that the 2020s feels like the 1920s. So this is a terrible analogy for fusionist coalitions that roam the hallways of the Mayflower and Federalist Society events. But everybody agreed in various strains of communism, whether they were Trotskyites, Leninists, Bolsheviks, whoever they followed, they knew that the ancient regime had to fall. But there were so many competing theories of communism that they ended up putting pickaxes in each other's heads and things like this. So thankfully, this is not going to be a bloody process, but I do think in terms of the search for the theory that holds together the coalition, I do think it's going to be as messy as Professor Graver.
Good. This is, by the way, just so you should know, the left, we do our firing squads in a circle.
The right is too.
Yeah, no, you've learned from us. I mean, there's some things we need to learn from you, but you've learned that from us.
Yes, sir.
So, Professor Moreland, I agree with you that history and tradition is a good mechanism of trying to delineate, and I think a good tool for judges. But I do think that Professor Graver's point is a valid one, that the historical perspectives of different generations and societies are indeed difficult to reconcile with our own. And I'm just curious, how do you think judges should try to incorporate that into their history and tradition analysis when they're actually taking on real cases?
Well, here, again, as I said very briefly, I do think that there's an article by Steve Saxon will vote on this, which I think actually was in a history journal, where they make
a response, not peer reviewed. I know the piece.
They make an argument that the judges do this in other domains as well. It's taking evidence as you do in different kinds of settings where you don't have expertise, and that so you can take this into account in various ways. So I think that's kind of one level of the answer. And we'll see how things play out. Sure, I mean judges are human beings. They probably they have personal views that might incline them toward one view or another of the background historical materials. But as the court develops this, I think again much more sound approach to constitutional interpretation, we'll start to see certain things will come into focus better. But unsurprisingly, we're going to have to live through this period of a kind of rethinking of some things after again the decades of I think rather misbegotten adventures in among other areas, but maybe among the most prominent of them being the Establishment Clause.
Oh, you haven't had a question yet.
Okay. So one of the things that we've heard a little bit about is the Establishment Clause in comparison with the Free Exercise Clause and maybe equal protection. To what extent are those kind of operating in different spheres versus sort of having a three-way tug of war over sort of the same content?
Here is an interesting feature where the historian actually comes in. One of the interesting features of the late 19th century is the United States became clause fetishist. That is, it starts really with Slaughterhouse, where the opinion goes, okay, here's the due process clause, this is what it means, here's privileged immunities, here's what it means, here's equal protection, here's what it means. You actually don't see that, for the most part, in the debate over the 14th Amendment, the 14th Amendment as a whole. If you read early 19th century opinions, they tend to be of the form, the Constitution protects this principle. How do we know? Look at these four provisions, and nobody says, this one does this little nook, this one does this little nook. So it's a mark of our jurisprudence, for example, that the court is fighting over whether it's the due process clause or the privileges and immunities clause that does the incorporation work. It's not a question. The reason why it's hard to answer, it's not a question the framers of the 14th Amendment asked.
Yeah, I think another factor, John Inazu has a book on the forgotten freedom of assembly. And so prior to, in addition to sort of clause fetishism, you also have jurisprudence fetishism, where people are chasing the magic words of case law and then building their arguments like a Tetris block to match and echo back to the court the words that it used. And that's how we lost assembly. So there's another reason. Nelson Rockefeller did propaganda posters that conditioned people to believe that there were four freedoms. Assembly was not one of them. So John Inazu, the forgotten freedom of assembly, a lot of this is because advocates quote back to the court a certain jurisprudential vocabulary, thinking it will woo the judges to do the same thing in their case, whatever. And so in addition to a hyperfixation on clauses, you also lose clauses because everything suddenly becomes expression. And we forgot that, a lot of these cases are about speech, assembly, and we can read more of those to a more historical understanding. So while we're on the topic of lawyers and their fetishes. Another question.
I guess, given that on the one hand we have a court that writes opinions pretty much just to argue with each other, but on the other hand we have a court that takes maybe 50, 60 cases a year, do you think there's the interest from the court in going back and cleaning all this up and doing a grand unified theory of interior decorating? Or do you think they will just sort of do it
Reindeers, but no,
by silence?
no moose.
Like, do you think they'll just sort of leave it alone and take your approach?
Professor Moreland.
In part because of my role as chair of the Federal Society's Religious Liberties Practice Group, we do a lot of programming around, Supreme Court issues. It is interesting that, I guess depending on how you frame certain cases this term, but there isn't kind of a blockbuster law religion case or free exercise or establishment clause case this year. I do think that my reading of the tea leaves is that on the establishment clause, things are just going to kind of peter out for a while. They're not going to take, except possibly the funding issue with regard to things like charter schools and maybe follow on, implications of that. But I think that in areas like symbols and displays, prayers, things like that, I think that things are just going to kind of sit there for a while. We'll see. We've gone through an era in which free speech, for instance, there are a lot of big free speech cases that continues even now. There are a couple, at least one big, that Colorado case involving conversion therapy, where the court was going to weigh in on a free speech issue. But free speech might be one of those things that too will kind of sit there for a while after this period of action. So hard to know kind of what will be of most interest to the many in time.
Your take, Professor Graber.
That feels about right to me. Let me suggest that what a court does, a court like this, which has a clear majority, is it will take the law here, and at a certain point, first it does the fixes. As from a conservative perspective, you think the Establishment Clause needs to be fixed, and it's doing that. Lemon is dead. I would not cite Lemon in a court unless I was guaranteed a liberal district judge, and I had to win, and I didn't care about appeal. Would not bother doing that. And I think you're right in that one of the things the charter school case indicated is the majority has about run to where its agreement is running out. I don't think in free speech the majority has run as far. I don't think in voting rights the majority has run as far as they want to go. And so those would be the areas. And by the way, if you start to see more divisions among the court, it's not that somebody has turned liberal. It's that just as O'Connor really wasn't as liberal before, rather O'Connor moved the court from here to here. And then at here, Rehnquist said, let's go further. No, I'm happy here. That's what we're seeing. I think Roberts is getting more and more happy. Thomas and Alito are not happy, but they're happy, and that's going to be the challenge of, why one judge on either side will still matter a whole lot.
And Dennis, how are we on time?
We can end at 7:15, so one more question.
Okay. You get to be the last question. Congratulations.
That's a good one. So this is primarily for Professor Moreland, but I'm going to get Professor Graber's thoughts too. So other than school prayer and maybe the state establishing a church, are there any other areas where maybe the more history and tradition approach to the Establishment Clause might conflict with the modern jurisprudence and understanding of the Free Exercise Clause? Or do you think it sort of mostly matches the history and tradition of how free exercise was understood in the past?
Say again that part about free exercise?
Or do you just not think that they would ever conflict that much theoretically? Like if you ruinized the Free Exercise Clause or something?
I guess I'm inclined to agree with the thrust of where you're going, in part because part of the correction here is the correction to a way of reading free exercise and establishment in tension with each other, which you saw in a lot of cases. Like the question about, for instance, in the context now pretty much settled, but is accommodation in the interest of free exercise by statute, for example, does that violate the Establishment Clause? And for a while there, the court seemed to be kind of, well, maybe it does. Like maybe accommodations are an Establishment Clause violation. And then in cases like Amos, for instance, set that aside. And I think that's because of the way in which now free exercise and establishment are read together, so that, for example, the free exercise non-discrimination principle with regard to aid and funding of schools doesn't violate the Establishment Clause, whereas I think 40 or 50 years ago, the court was wrapped around the axle on questions like that. But I think now they have a much more coherent and synthetic, as it were, way of rendering the two clauses together.
I'll just conclude by noting that, in one sense, the Rehnquist and Roberts Court are the greatest thing that ever happened to me, because as a good political scientist, I wrote a piece on the way politics influenced the Supreme Court, which at a time when people still thought the Supreme Court was a liberal institution, liberals said can't possibly be right. Now that conservatives control the Supreme Court, well, of course it's all politics, just the way Graeber told us. And one of the consequences of being all politics is my side will believe it is all politics, and your side will in fact believe there are a set of historical principles going on. And when the wheel turns, as it may when some of you get to be my age, I can promise you, my piece will be discarded. Because liberals will say the Rebecca Graeber, my youngest daughter, court, is based on enduring history and political principles, and your granddaughter will write a piece showing it's all politics.
Okay, with that, we'll conclude our event. Thank you for everybody coming out.
Thanks so much, guys, for coming. Our next debate's on judicial restraint, so very relevant.
Yeah, you love
Of course.
I am actually trying.
Fair, yeah.
Okay, so
Incorrect.
Okay.
What's the
I know we-
I need these.